Yeah.
Oh, it's got that truth serum in it.
Commissioner Alvarez. Julie is back.
Show before or after.
Ready to roll.
Good morning, everyone. This meeting is called to order. Ms. Patricio, is there anyone signed up for public comment?
Good morning, Commissioners. We have one person signed up for public comment, Melissa Laurel.
Thank you.
Ms. Laurel, if you would please unmute the microphone and proceed. It doesn't look like Ms. Laurel is on this morning.
Thank you very
Thank you.
much. Good morning, Ms. Miller.
Good morning, sir.
No cases to reconsider under agenda item 3.
Correct, none.
Let's move to tax liability cases under agenda item 4. But see, we have no tax cases on docket 17.
That's right. No cases today.
Fair housing cases?
Not today.
Not today. Under agenda item 6, we have no wage claim cases on docket 17 pulled for additional discussion.
That's correct. None pulled, but you should have received the wage claim short form dissent list for docket 17.
I'll move we accept staff recommendations on the remaining wage claim cases on docket 17.
I second the motion, except for those cases in which I'm dissenting as reflected on the wage claim short form dissent list for docket 17.
I encourage the chairman's motion, except for cases on which I'm dissenting is reflected in the wage claim short form dissent list for docket 17.
Motion passes with the exceptions noted. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 17. Please proceed when you're ready.
Case number 2703285, Commissioner Alvarez.
The decision is not supportable. The claimant was partially unemployed, working a position that paid $9 per hour. She quit that position to accept work that would pay her $10 per hour. In accordance with section 207.045G of the Act, the claimant should not be disqualified. Reverse the AT, no voluntary leaving, no overpayment.
The appeal tribunal decision should be affirmed. The employer was a home health agency. In addition, the claimant clearly notified the employer that the working relationship had ended when she quit for a personal reason unrelated to the work and filed for unemployment benefits. The claimant stated in fact-finding statements that she quit her job because school was starting again and that she would not have quit if she was not going back to school. This reason for quitting does not constitute good cause connected with the work. Since the claimant's fact-finding statements were provided closer to the time of the job separation, they should be given greater weight. We should therefore affirm the AT decision, voluntary leavings, overpayment of $1,177.
Affirm the AT, voluntary leaving, overpayment.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2770468, Commissioner Alvarez.
The AT should be modified. The claimant quit her job as a teaching assistant at the end of a high-risk pregnancy. The claimant informed the employer that her activity was restricted, and she provided a note from her doctor that listed the restrictions. The employer complied with the instructions only 3 weeks before giving birth. Contractions. The claimant should not be disqualified because of her health problems, which had been medically documented. And because the claimant separation was caused by medically verified health problems, the employer's account should be protected. Modify the AT, no voluntary leaving, no chargeback due to MBI.
We should affirm the appeal tribunal decision. Although the claimant had medical restrictions due to pregnancy, she was not advised by her doctor to quit. Additionally, 2 employer witnesses testified that the employer accommodated these restrictions. Thus, because the preponderance of the evidence established that the claimant quit her job while work was still available to have more time to prepare for the birth of her child, the claimant quit for personal reasons and not for good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback. However, if my fellow commissioners disagree and believe that the separation resulted from the claimant's pregnancy, the employer's account should be protected from charge in accordance with commission precedent, appeal number 87-02-634-10-022-588, which held a separation caused by the claimant's pregnancy is a separation caused by medically verifiable illness within the meaning of section 204.022 of the Act, thereby compelling the protection of the employer's account from the chargeback.
Modify the AT, no voluntary leaving, no chargeback, MVI memo to investigate availability.
So, Mr. Chairman, no voluntary leaving?
Mr. Chairman, your vote agrees with Commissioner Alvarez, correct?
I believe so.
Pay and protect.
We're okay with that.
Okay, we have a unanimous vote and we will send that memo, sir.
Case number 2788975, Commissioner Alvarez.
This case was scheduled for hearing to address the timeliness of the claimant's appeal. The rehearing notice was returned to TWC. Since the claimant clearly did not have notice of hearing, a new hearing should be scheduled and the claimant again provided an opportunity to testify. Rehear.
The claimant's commission appeal was filed beyond the applicable deadline to be considered timely and should therefore be deemed late. There are no good cause exceptions to the timeliness rules. As such, we should dismiss the claimant's commission appeal as late and leave the underlying decision in full force and effect.
Rehear.
We'll rehear the case.
Case number 2854344, Commissioner Alvarez.
The decision is not supportable. The claimant's hours were reduced after the assignment ended and only job offered to her was another community approximately 30 minutes away from her house. The distance was beyond what the claimant had traditionally worked for the employer. Reverse the AT, no voluntary leaving chargeback. Alternatively, as the record was not well developed regarding the claimant's distance and commute time to her prior assignments, or how it would have impacted her on her new assignment, I would agree to another rehearing.
We should affirm the appeal tribunal decision. After losing one of her assignments, the claimant was offered further work with more hours in a neighboring town. By refusing this assignment, the claimant initiated the job separation. Because the new assignment was in town less than 20 miles away and the commute was not unreasonable, the claimant did not establish good cause for rejecting the assignment. Accordingly, we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2864170, Commissioner Alvarez.
Okay, I don't have that case.
Just to clarify, it's case number 2864170.
Moment to speak.
Do you need a short break, sir?
That's correct. So if I could have a 5-minute break real quick, just to locate it.
We're in recess.
Thank you.
Thank you.
Ms. Miller, I apologize for the inconvenience and to the commission as well. Can we come back to a later? I have it. It's being printed and being delivered by staff. If you don't mind, Chairman, can we move to the next case? Come back to it, or do you want to continue waiting until she brings it down?
Let's just stand in recess. until
Okay.
we get- I don't want to get out of order just for
Okay.
staff's well-being.
I got it.
All right, from the top, remind us of the case number.
Case number 2864170, Commissioner Alvarez.
Thank you, Ms. Miller. The AT decision in this case should be set aside and the documentation, correction, and the determinations on the appeal should be considered void from inception. The documents in this case clearly establish that the claimant was a server and was laid off for 4 weeks. The employer paid the claimant and statutory minimum at the statutory minimum wage servers at $2.13 an hour for those 4 weeks. For the wage records reported by the employer to the commission, the vast majority of the claimant's wages were paid in the form of customer tips. Since the employer only paid a small fraction of the claimant's actual wages for the weeks in which he was laid off, the claimant cannot be considered disqualifying severance pay, and the determinations in this case were therefore void from inception. Set aside the AT decision and void the determinations dated May 18, 2020 and May 22nd, 2020. In the alternative, I would also agree to remand the case to the appeal tribunal for testimony on the timeliness issue. The appeal tribunal took no testimony on the timeliness issue and simply dismissed the appeal as late. The claimant has argued that he attempted to file earlier appeals and that system malfunctions prevented his earlier appeals. Evidence should be taken on the timeliness issue to determine whether the claimant's appeal should be deemed timely. Set aside AT and remand to the AT for timeliness testimony.
We should affirm the AT decision. The claimant filed his appeal beyond the applicable deadline to do so. The available record dictates that the claimant received and thereafter opened the TWC determinations within the appeal period. The claimant filed his appeal almost a month after the determinations were mailed to him. Since the claimant filed late appeals, and because there are no good cause exceptions to the timeliness rules, we should affirm the AT decision, untimely claimant appeal. Severance disqualification from March 22nd, 2020 through April 4th, 2020. Overpayment of $708. Also severance disqualification from April 26, 2020 through May 9th, 2020. Overpayment of $708.
Reverse the AT, timely claimant appeal, remand.
Short form dissent.
Yes, sir.
Okay.
Case number 2917672, Commissioner Alvarez.
I don't have that one either. No, I'm just kidding. Just kidding. Just want to see my staff again react. Kind of like that. The AT decision is not supportable. The underlying issue in this case is whether the claimant worked customary full-time hours. This case involves the issue of validity of claim and therefore falls within the exception of the timeliness rule. In 32I1, the claimant's AT appeal should be deemed timely and the case remanded for merits testimony.
We should reverse the appeal tribunal decision on timeliness. This case involves the issue of customary full-time hours. This issue is covered under section 201.091 of the Act, which includes guidelines for determining whether someone is unemployed. Hence, customary full-time hours can be viewed as a validity of claim issue. Since cases falling under the validity of claim category provide a one-time exception to the timeliness rules, we should find the claimant's appeal timely and remand the case to the appeal tribunal for merits testimony.
Reverse the AT, timely claimant appeal, remand.
Thank you. We have unanimous decision.
Case number 2948802, Commissioner Alvarez.
The AT decision should be reversed. The claimant was disqualified from receiving extended benefits because he allegedly failed to provide his work search log for the benefit week ending 1/16/21. The claimant has consistently held that he uploaded the work search log through the commission portal as required and believed that it had been successfully submitted. The timeliness rule in Rule 32 are only applicable to timeliness requirements under Texas Unemployment Compensation Act and do not apply to informal timeliness requirements as in this case here. The claimant's credible testimony that he submitted the work search log as required establishes by the preponderance of the evidence that he made a good faith effort to comply with the work search requirements. Reverse the AT, eligible for extended benefits, no overpayment.
The AT decision is supportable. The claimant had been instructed how to submit his work search log log for the weeks in question, but did not take reasonable follow-up actions when he failed to receive confirmation of receipt of the log by TWC. He could have contacted TWC about the issue, but did not. Accordingly, we should affirm the AT decision. The claimant is ineligible for extended benefits beginning January 10th, 2021, overpayment of $1,952.
Affirm the AT, claimant not eligible for extended benefits beginning January 10th, 2021, overpayment.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2965631, Commissioner Demerson.
We should modify the AT decision. The claimant was separated when he stopped performing services for the employer after a motor vehicle accident. The available record dictates that the claimant went on FMLA leave after his accident. Since the record shows that the claimant separation was a result of his medically verifiable illness, the claimant should be granted benefits and the employer's account should be protected from chargeback. Hence, we should modify the AT decision, no misconduct, no chargeback, MVI.
I would agree with Commissioner Demerson.
Affirm the AT, misconduct, no chargeback.
Majority of vote is pay and protect. Do you
Short
wish-
form dissent.
Yes, sir.
Case number 3008871, Commissioner Alvarez.
The AT should be reversed. This case involves an extended benefits claim. The claimant timely returned her completed work search log to the agency. The claimant was held disqualified based on her log not containing sufficient information or documentation sufficient variety in searches. But the form which the agency provided does not explicitly require a work search contact street address. The regulations required a sustained effort to find work. The claimant's work search log shows that she made work searches on different days of the week, and her searches included a variety of employers. She submitted resumes via those employers' websites, which is as stated in the federal requirements, in the same manner that such work is found by people in the community. And the more detailed form of log, which the claimant subsequently provided, shows that the answer of application filed is an acceptable response to the question of search results. Her first log note of submitting an online resume clearly indicates having filed an application. At our meeting on docket 13 on April 5th of 2022, it was stated that our notice of extended benefits is merely guidance into which is not binding. And noted the ambiguity between that is communicated to claimants about work search requirements versus the standards in which they are subsequently held. While I support requiring extended benefit claimants to make systematic and sustained efforts to search for work, we should not be disqualifying claimants based on formalistic interpretations of rules that have not been clearly communicated to participants. This claimant has met standards and should not be disqualified. Reverse the AT qualified for extended benefits, no overpayment.
We support that. The AT decision is not supportable. The claimant's initial submission of work search documentation was lacking in some technical respects, but she later attempted in good faith to supply the information that was lacking. There's no reasonable basis for finding that the claimant did not actually conduct a valid work search during the weeks in question. Accordingly, we should reverse the AT decision. The claimant has documented her work searches during the relevant weeks and is eligible for extended benefits beginning July 25th, 2020, no overpayment.
Reverse the AT, claimant's eligible for extended benefits, no overpayment.
Thank you. We have unanimous decision.
Case number 3012531, Commissioner Demerson.
The AT decision is fully supportable. The employer's policy detailed that an officer's use of force must be objectively reasonable based on the totality of the circumstances. The claimant was terminated when the employer's investigation detailed that he had used unreasonable force to subdue another person. Since the available record dictates that the claimant's second use of force per the employer's investigation was not objectively reasonable, the claimant's actions constituted misconduct connected with the work. Hence, we should affirm the AT decision, misconduct, reimburse an employer not billed, sever the adequate employer response issue.
The employer merely provided secondhand testimony concerning the final incident in question. The claimant denied under oath that he violated the employer's policies and maintained that he was following his training and experience in this situation. Therefore, the employer did not carry its burden of proving that the claimant was guilty of misconduct connected with the work. Accordingly, the AT decision, which disqualified the claimant from receiving benefits, should be reversed. Reverse the AT, no misconduct, bill reimbursing employer, void adequate response.
Modify the AT, misconduct, reimbursing employer, not billed, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3022570, Commissioner Alvarez.
The motion for rehearing should be granted. The claimant was discharged for an alleged sexual harassment, which she has consistently denied. The commission has previously voted to affirm her disqualification for benefits, but her motion includes new evidence, including the name and contact information of a coworker who has recanted the allegations of sexual assault. The claimant took a recording. The claimant took a recording of the coworker's statement after the commission voted on her earlier appeal. And the coworker statement recanting the allegations of misconduct for which the claimant was discharged would clearly change the outcome of the case. Because the claimant has met the standards for granting a motion for rehearing, we should rehear this case to enter her new evidence into the record for evaluation.
The claimant has not met the required criteria for MR to be granted. Accordingly, we should deny the claimant's motion for rehearing.
Deny the motion for rehearing.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3074969, Chairman Daniel.
Can you read the number for me?
Yes.
3074969.
3074969.
Yes, sir.
Because the employer's appeal timeframe occurred when TWC systems were overwhelmed, the appeal should be deemed timely. Regarding the chargeback issue, because the claimant quit for another job, had this been the last separation prior to the IC, the claimant would have been disqualified, and the employer's account would have been protected. The employer should not be charged. Reverse the AT, timely response to the NMPC, no chargeback.
Ms. Miller, can I hear that case number again?
3074969.
Perfect. The AT decision is correct. The agency mailed notice to the employer's correct address, and the employer admits there was no delay in their receipt. The employer failed to respond timely because they had a large number of documents to which they needed to respond. The employer's ability to respond to notices within their control. Affirm the AT, no timely protest.
The AT decision is not supportable. On docket 12, regarding a similar case involving the same employer, I noted that lack of proper information can be just as misleading to a party as improper information that is given to a party. In other words, misleading a party by omission of relevant information should be treated the same as misleading a party by supplying wrong information. In this case, the employer was not told on the notice of maximum potential chargeback that it could have dealt with its claim volume problem by simply sending TWC a spreadsheet of all of the NMPCs that it needed to protest. That is certainly an option that is available, and it should have been mentioned on the NMPC, particularly in the context of the pandemic, when claimants, employers, and TWC were all overwhelmed by the volume of claims, appeals, and related proceedings. If the employer had had the proper information, it could have responded to the chargeback notice on time. Accordingly, we should reverse the AT decision. The employer filed a timely response to the chargeback notice, resubmit on the merits of the work separation.
We have a majority vote that the notice was timely, but not a majority vote on the underlying chargeback issue. The chairman voted to protect the employer's account, no chargeback. And Commissioner Demerson, you voted to resubmit.
Submit.
So we need to achieve a majority vote or resubmit, which also would require majority under this particular circumstance. Basically, we need a majority vote on whether to resubmit or to just protect the employer. And right now, we've got one vote each way.
Ms. Miller, I would agree to resubmit. Change my vote.
Thank you.
So I would go with timely employer protest and resubmit.
Thank you, sir. We will resubmit on the chargeback issue.
Case number 3029897, Commissioner Alvarez.
Read that again for me.
The case number
Yes, please.
3029897.
Thank you.
The AT decision is not supportable. The uncontradicted firsthand testimony and evidence from the claimant establishes that the claimant was fired by a manager with authority to do so. Another higher level manager later called the claimant to tell him he could return to work on the following day. However, this manager was present when the claimant was discharged and did nothing at the time to overrule the manager who was firing the claimant. At that time, he was told to get his things and leave, and the claimant thereby was separated from his job. The fact that the later refused to return to employment after the separation does not change the nature of the separation. Moreover, it would be unreasonable to expect the claimant to return to work given the actions of the manager who fired him. The claimant was fired after he refused to lie to a customer on behalf of the manager, and he swore at the manager, was sworn by the manager, and was swore at by the manager. The claimant reasonably chose not to return to work in response to his extremely unprofessional behavior after he had been discharged. The claimant was discharged for reasons that did not constitute misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response.
We should modify the AT decision. The claimant quit due to dissatisfaction with his working conditions. Although the claimant alleged that the desk manager had fired him, the claimant provided sworn testimony that the general manager, who was the desk manager's supervisor, advised the claimant that he was not fired and that continued work was available to him. Furthermore, the record dictates that the claimant failed to address his concerns with HR or provide the employer with an opportunity to address his concerns prior to quitting. Since the record reflects that the claimant had continued available work at the time of the separation, the claimant's separation constituted a voluntary quit without work-connected good cause. Hence, we should modify the AT decision, voluntary leaving, no chargeback, sever the adequate employer response issue.
Modify the AT, voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3070305, Commissioner Alvarez.
The AT should be reversed. This case involves an extended benefits claim. This is another case where the claimant timely submitted her work search logs, but the AT disqualified the claimant for allegedly not demonstrating a systematic and sustained effort to obtain work. I continue my objections to disqualifying claimants for a formalistic interpretation of regulations that have not been clearly communicated to participants. This claimant's work search logs document that she reached the required number of work searches, and she met the program requirements of engaging in systematic and sustained efforts to obtain work in a manner consistent with community standards, including the use of the agency's own workintexas.com website. She should not be disqualified. Reverse the AT and qualified for extended benefits, no overpayment.
The AT decision is not supportable based on the available evidence. We have been allowing extended benefit work searches that were all done online because of the ambiguous messaging to extended benefit claimants concerning the specific expectations of work search contact methods. However, the claimant in this case listed only job contacts made on one day. The instructions are not ambiguous about the expectation that job contacts be made on more than one day per claim week. The claimant's appeal to the commission asserted that she did in fact search for work on more than one day that week. Unfortunately, the hearing was only 10 minutes long, and the hearing officer apparently did not ask about that important aspect of the work search requirements. Accordingly, we should hold a rehearing to obtain additional evidence concerning the days on which the claimant looked for work.
Texas Labor Code Section 209.043 requires claimants to engage in a systematic and sustained effort to obtain work. There's no requirement in statute or in rule mandating that work searches have to be done using a variety of methods. The recommendation that the claimant was not eligible because all the work searches were performed online is neither legally sound nor persuasive. Online work searches are sufficient, and the claimant should be eligible for extended benefits. Reverse the AT. Claimant is eligible for extended benefits, no overpayment.
The majority vote finds the claimant is eligible and there is no
Okay,
overpayment.
so I'm gonna short form dissent.
Yes, sir.
Case number 3080659, Commissioner Alvarez.
The AT decision should be affirmed. The claimant worked as a producer for this for this insurance agency for 2 months. The employer testified that the claimant was fired after never having met her performance expectations, and commission precedents holds that this is not misconduct. The employer also testified that they found a prescription bottle in the claimant's desk that was not in his name. But this isolated fact without context is not sufficient to prove misconduct. The employer did not testify that the claimant took drugs illegally or how the prescription got in the office or whose name was on the prescription. Given the employer's clear testimony as to why the claimant was discharged and the lack of evidence about the prescription, the record does not support disqualifying the claimant for misconduct. Affirm the AT, no misconduct.
Good. I'm gonna make sure this is a case number 3113475, correct?
3080659.
We should reverse the appeal tribunal decision. The day before the claimant's discharge, the employers discovered that the claimant locked his door to clients and had prescription drugs not prescribed to the claimant in his desk. Thus, the claimant mismanaged his position of employment and was discharged for misconduct connected with work. We should reverse the AT decision, misconduct.
Reverse the AT, misconduct.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 3113475, Commissioner Alvarez.
The decision is not supportable. The claimant suffered a back injury for which he has provided medical documentation. The injury worsened and he requested accommodations to ease the pain. After no accommodations was given and he exhausted his PTO, he quit. The claimant's quit was due to medical issue and is not disqualifying. Reverse the AT, no voluntary leaving.
We should affirm the appeal tribunal decision. I do not dispute that the claimant may have injured his back. However, the claimant's doctor did not advise him to quit due to his medical issue. Furthermore, in his fact-finding statements, the claimant admitted that he did not return to work after the doctor released him to work with restrictions. By failing to return to work after his medical visit, the claimant did not give the employer an opportunity to accommodate his restrictions. Finally, the claimant did not request FMLA leave for his back condition before quitting. Because the claimant did not explore all available options to protect his employment and had not been advised by his doctor to quit, the claimant quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving.
Affirm the AT, voluntary leaving.
Short form dissent.
Yes, sir. Commissioner Alvarez. And that was the last case pulled for additional discussion on docket 17. You should have received the UI short form dissent list for docket 17.
Move
Chair,
we accept-
Before we go forward, can I just, I want to go back to one case and I want
Certainly.
to consult with the staff on that one. So let me take a second to do that.
Yes, sir.
Some of the cases were ordered and then I lost one.
Chair, I'd like to go back to a particular case and I'll give you the case number.
Yes, sir.
It's case number 2965631. So it's 2965631.
Yes, sir. That appears to be the eighth case.
2965631.
2965631.
Yeah, on that case, we were going with no misconduct, no chargeback, MBI. But can you read the chairman's vote again?
I have recorded the chairman's vote as to reverse, no misconduct chargeback. However, since there was a majority vote for MVI, the majority vote is no misconduct, no chargeback, and the chairman short form dissented on the chargeback issue. I'm sorry. Commissioner, Mr. Chairman, could you please repeat your vote for case number?
2296561.
Yes, sir.
I have misconduct, no charge.
Okay.
Mr. Chair, I'm going to change my vote for that MVI, and I want to agree with the chairman on that vote.
Okay. Misconduct, no chargeback has become the majority vote.
Thank you.
Which means MVI is no longer the majority vote. The claimant is disqualified.
Short form dissent.
Yes, sir, Commissioner Alvarez. Thank you, Commissioner Demerson.
Thank you.
So that concludes the pulled cases for docket 17. And you should have received the UI short form dissent list for docket 17.
I'll move we accept staff recommendation. Let me turn that microphone on. How about now? I move we accept staff recommendations on the remaining UI cases on docket 17.
I second the motion, except for those cases of which I'm dissenting as reflected on the UI short form dissent list for docket 17.
I concur with the chairman's motion, except for the cases on which I'm dissenting is reflected in the UI short form dissent list for docket 17.
Motion carries with the exceptions noted.
Thank you, sir.
Thank you. Mr. Cerna, is there an executive director's report today? We should just get Mr. Cerna like a handheld microphone. Yeah, more like a headset, like a TED Talk. Would look very professional.
We have one item legislative update.
Thank you.
Morning, Mr. Chairman, Commissioners, Mr. Cerna. For the record, Michael Britt, Governmental Relations. I wanted to update you all real quick. TWC has been requested to testify at several upcoming Texas House and Senate interim hearings. Mr. Cerna will be testifying tomorrow, April 27th at 1 o'clock in the afternoon before the House Committee on Business and Industry. The committee will be taking up 2 interim charges at the hearing related to TWC. One is related to operational changes and strategies employed by TWC to improve outcomes related to UI benefits, and another charge related to studying the impacts of the pandemic on unemployment trends and hurdles to workforce reentry and industry-specific disruptions. Then on Tuesday, May 3rd, Bob Gear will be testifying before the Senate Committee on Veteran Affairs. TWC has been requested to testify on the committee's interim charge related to veteran benefits. On Tuesday, May 10th, Chairman Daniel will be testifying before the Senate Committee on Higher Education on the committee's interim charge related to workforce education, and also the committee's monitoring charge related to House Bill 3767 from the 87th Texas Legislature. Finally, on Wednesday, May 11th, Chairman Daniel will also be testifying before the Senate Committee on Water, Agriculture, and Rural Affairs on the committee's interim charge related to rural employment. That concludes my remarks. I'm happy to answer any questions y'all have.
Thank you. Any comments or questions?
None for me.
Thank you very much. Mr. Cerna, anything else? I do have one thing since I've got you here. We've been working, TWC's been working on several fronts to address shortages in the healthcare industry, but I'm starting to hear about the potential for some limitations on our programs that could slow down those efforts. For example, Commissioner Alvarez recently proposed what I think is a really good healthcare apprenticeship initiative. But when we take a look at our rules and other agency policy, we see that a key stakeholder, which specifically I'm talking about public sector healthcare workers, specifically county hospital nurses or something along those lines, they might be unable to participate due to requirements that eligible grantees be private entities. I know of a similar restriction in the Skills Development Fund program. At a commission meeting in the near future, would you please have staff bring back a plan to tell us what those potential limitations may be for these public sector healthcare workers, and what steps this commission might need to take to eliminate those particular barriers to their participation?
Yes, sir. We can do that as quickly as possible.
Thank you very much.
Mr. Chairman, on that, you're talking about the public sector employers that are out there. Okay.
Yeah, I'm specifically, I'm worried about so many hospitals are either county or city run entities, particularly once you get out of the metro areas. I just want to make sure that, I mean, the nursing shortage doesn't really care if your employer is private sector or public sector. And so I want to make sure we've got all our bases covered.
Yes, sir. We had a small effort, just as a way of sharing with the commission. We had a small effort, I think about a year ago, working with Commissioner Alvarez, sort of a pilot, not specifically in healthcare, but just in general skills development in the public sector. So we will expand that, but then also come back with specific details about what we need to remove those barriers.
Thank you, Mr. Cerna. Is there any other order of business come before the commission?
Chairman, I think that's a great recommendation, and so I appreciate that,
Thank you very much.
especially with the I'd also like to ask if we could add, if, again, I appreciate those comments, Chairman, if we could include recommendations for guidelines so the public can participate in this particular agenda item.
Yes, sir.
So Commissioner Alvarez, you're talking about public input? From that standpoint, okay.
But I like the idea of what the chairman has addressed. Just this morning, we were talking about what the Texas State Systems is doing in an application to increase the number of nurses in the state by applying for a grant with the Department of Commerce for $70 million. And so they're one of 60, there were 500 applicants, and they're one of the top 60 that are still in the hunt for the money. So this recommendation that you made, Chairman, certainly is appropriate at this time.
Yeah, my only comments, basically, Texas is booming. Had an opportunity to be out in Pearland, Abilene, Alvin, Texas, and Texas City, Texas, and activities are just increasing, and there's an appetite for the Texas Workforce Commission programs. So our 28 local workforce solution boards are very, very, very busy out there, as is the TWC team. So just appreciating all the work and the energy that's out there. It's pretty exciting.
All right. Do we have a motion to adjourn?
Chairman, I move that we adjourn.
Second.
It's been moved and seconded to adjourn, and we're adjourned.